What's going on with the FTC as it relates to privacy in healthcare?
Yeah. So I think the main thing to take from that warning letter is that the FTC is just as concerned about this as the OCR is. And, even more so now that OCR does have, some limitations based on their ruling. I don't want to ignore that. There was an effect and they do have some restraints now, but FTC is not constrained by that ruling. It impacts the definition of PHI, and FTC doesn't deal with covered entities in their role under HIPAA. And so maybe we'll see them kind of stepping up a bit more now while OCR is trying to figure out what they do. But the fact is that it's not like they've been silent either to date. I mean, we've seen them really going back to this 2022, 2023 period, really seen them step up in terms of what they're saying about tracking technologies, guidance. They do that in two main ways that we've seen to date. One is under the FTC Act, which probably everyone kind of thinks of traditionally with the FTC, no unfair or deceptive trade practices. But another one they've come up with, it's been in place, but they're starting to enforce against it and really only did it for the first time last February, is their health breach notification rule. That basically says that entities who are not covered by HIPAA, like, wearables or fitness apps, things like that, they are subject to the health breach notification rule. And if they share information in a way that's not permitted, they have to notify consumers about that, very similar to the breach notification rule under HIPAA. And we saw the first one with GoodRx back in February, then the second one in May of 2023 in a very similar case within an ovulation tracking app. What's really interesting about these ones is that unlike the FTC Act, which only applies to for-profit entities, the health breach notification rule can be enforced against nonprofits to the extent they have this type of information. And while it's interesting to see a novel theory being applied and that these settlement amounts aren't, anything insignificant, you can see the amounts here. What's really, I think, notable about these settlements and these consents is that these entities, we're seeing it in all of them, are being permanently prohibited from sharing any information for advertising purposes. And then any other type of sharing of information to a third party requires the consumer's affirmative consent. So, I mean, for a marketer or for someone who's, wants to use any type of information from a website or an app, they're locked. I mean, there's nothing they can do.
Yeah, that was shocking to me. I know Cerebral was a recent one, and part of their settlement was that they would not send data to most marketing tools, which to me would mean if you have a digital advertising acquisition strategy leveraging Facebook or search ads, and you can no longer send data to those, anybody who knows anything about these tools knows they're not going to be very effective anymore. And that's probably even bigger than the near-term fine, is being locked out of your growth motion, which was shocking to me.
So they've seen serious business with these, with these enforcements.
I can just say, probably in many cases, depending on the revenue of the company, getting a fine is survivable, but getting strategically locked out of your way to grow the business and reach your consumers, big deal. It's not easy to pivot from digital advertising to just billboards. It's pretty difficult with some of these products.
Not in 2024, that's for sure.
No.
Yeah.
You mentioned to me that in some of these, the prescribed combination that we were talking about before of IP address plus context was exactly what was called out in some of these settlements. Can you tell me a little bit about that?
Yeah, we were talking about the BetterHelp complaint in that one. I thought this was really interesting. There's a quote up here on the screen. Just for background, the BetterHelp settlement consent was around the FTC Act. So essentially what FTC said was that BetterHelp had made all these promises on its website, and they actually included screenshots of these in their complaint. There are many of them saying how information would always be private. They would never share it with anybody. The therapist wouldn't even see it in some cases. And so when they shared that with advertisers and other third parties, that was the deceptive trade practice. They also said, and this one is just as kind of shocking as the never sharing the information again. They said because the BetterHelp didn't get affirmative consent not an opt-out, not something implied by reading the terms and conditions, but affirmative consent from individuals to share their health information, that was an unfair trade practice. And so one of the things they specifically called out in the complaint was this visitor, their IP address, in combination with something about what they did in their visit, like an intake questionnaire or something like that. When those two pieces were disclosed together, that's what tripped the health information being disclosed. And so, I mean, I see IP address here plus a visit to the website, and that really sounds awfully familiar to the prescribed combination.